Hey, this is Kendra with Signing Agent Basics, and in this video, I'm going to tell you some of the things that you should not do as a signing agent. On my Instagram and Facebook pages, I post a lot of fun memes about the signing agent industry, like this one, and this one, and this one. However, I occasionally use terms in those memes that may be unfamiliar to new signing agents, and I'll get private messages from those signing agents asking me for more information and clarification. In this video, I'm going to go over 3 of the most recent terms that I've used that I got a lot of questions about, and not surprisingly, these terms are directly related to some of the most common mistakes that I see new signing agents making. A lot of times, these mistakes can not only be improper, but they can also be illegal depending on the laws in your state, so you'll definitely want to avoid them. The first thing I want to remind you before I go into details about these mistakes is that I am not an attorney. It is your responsibility as a commissioned notary public to know and follow the notary laws in your state. What is acceptable in one state may not be acceptable in another. And notary laws do change periodically. What may have been allowable in years past may no longer be allowable, and vice versa. Make sure that you stay active and up to date in your knowledge of your state's notary laws. You will probably find it very helpful to bookmark the website for the governing body for notaries in your state. Here in Texas, it is the Secretary of State's office. You can also follow reputable websites such as the National Notary Association. The National Notary Association often provides valuable information about the proper way to handle notarizations in general and specifics regarding changes and updates to notary laws in your state. Now, before I tell you the 3 things that you should not do as a signing agent, what do you think the 3 points are going to be? And what do you do when you run into a notary signing agent issue that you are unsure of? Go down into the comment section right now and let me know. No matter what, go ahead and give this video a thumbs up. Okay, one of the first things you should not do is notarize a document without proper identification from the signer. Some states do specify the types of ID a notary may accept to identify a signer, and some states leave the determination of an ID's suitability up to the notary. One of the ID issues you may run into as a signing agent is a signer who has one last name on their ID, but a different last name on their documents. This often happens in the case of women who are recently married. In some states, notaries may not perform a notarial act when the last name on the document and the last name on the government-issued identification cards do not match. If your state does not allow this, then you must refuse the notarization. Another issue is using an expired ID. Different states have different requirements as to whether or not an expired ID is acceptable. Some states require that the signer have a current ID, and some states accept expired IDs if they were issued within the past 5 years. The laws in some other states don't specify whether an ID has to be current, valid, or unexpired, so a professional best practice is to only accept unexpired IDs in those instances. The next issue that I want to address is backdating and post-dating documents. Backdating is the practice of marking a contract or other legally binding agreement with a date that is prior to the current date, while post-dating is the practice of marking a contract or other legally binding agreement with a date that is later than the current date. Backdating and post-dating are usually not allowed on documents that do not require notarization. Backdating and post-dating are never allowed on a notarial certificate. And both situations can even be considered fraudulent or illegal. So why would a company even ask a notary to backdate a document? One of the reasons why notaries are sometimes asked to write in an earlier date is to lock in a lower mortgage interest rate. In some instances, if a mortgage isn't completed by a specified date, the borrower could lose their interest rate. So companies may attempt to persuade the notary public to include a date prior to the actual signing. Whether you are asked to backdate or postdate a notarial certificate, you should refuse. The execution of a notarial certificate must always contain the actual date of the notarization. The notarial certificate must never be postdated or backdated to accommodate the signer or anyone else. Another mistake that new signing agents may make is providing anyone a signed and stamped notarial certificate that is not attached to a particular document. I will occasionally receive loan packages with extra blank notarial certificates, and I've even been asked to complete, sign, and stamp these certificates and send them back with the signed documents to be used in case there is an issue. The contracting company may say that they want the extra certificates to rectify any mistakes the notary signing agent may have made in completing a certificate on the mortgage, deed of trust, or other notarized document in the loan package without having to send the entire document back for the signing agent to correct, which may delay the closing of the transaction. Now, while that may sound good in general, a notary public should never provide a completed, signed, and stamped notarial certificate that does not specifically go with a particular document. Many states' notary laws outright prohibit this action, and even for those states that do not specifically address the issue, the Notary Signing Agent Code of Conduct, drafted by the Signing Professionals Work Group, specifically prohibits notary signing agents from complying with such requests. Now, sometimes you may be asked or even pressured by a contracting company to accept an unacceptable form of ID, backdate or postdate documents, or provide an unattached notarial certificate. This may be because the representative of the contracting company is unfamiliar with notary law in general or the notary law in your state in particular. However, you need to remember that you are not an employee of the contracting company, whether it is a signing company, title company, or lender. They cannot require that you do anything that is improper or illegal in your state. Simply put, you cannot use "the signing company told me to do it" as a defense. It is your responsibility as a commissioned notary public in your state to familiarize yourself with and follow your state's notary laws. While it may be uncomfortable and you may be concerned about losing future business from a company, you must be willing to say no and refuse notarization if you are ever asked to do something that goes against notary law. To help you guys out, I've put links to the National Notary Association and the Signing Professionals Work Group down in the description box. So, signing agents, was this video helpful? Do you now understand these 3 things that you should not do as a signing agent? If so, go ahead and hit that thumbs up button right now. And have any of you ever run into any of these situations or circumstances? If so, go down into the comment section and let me know. Also, if you found my videos helpful and you want to know how I can help to train you to be a more productive and profitable signing agent, go down into the description box for more information about my training program. And if you are not already following me on Instagram, LinkedIn, and Facebook, make sure that you do that today. Links to all of my socials are, you guessed it, down in the description box. And no matter what, make sure that you hit that like button, hit the subscribe button, and then hit the notification bell so that you don't miss any of my upcoming videos. This is Kendra with Signing Agent Basics, hoping that you have a productive and profitable day.